violating the motion to enter, rather, the deferred adjudication. That pleading of two allows me to revoke, or rather enter an adjudication of guilt. Do you understand that, ma'am?
Yes, sir.
All right. Mr. Edelman, you were making a remark.
Yes, sir. I simply wanted to state that it is not a foregone conclusion that the court may proceed to sentencing. The court is still entitled to deny the MTR, even though Ms. Fuentes has pled true to the violation.
I understand. Thank you. All right. Ms. Fuentes,
Yes, sir.
tell me why you chose not to, well, rather, tell me why you chose to break your word to the court when you were placed on deferred adjudication and you uh, failed, in my opinion, refused to live up to the conditions of deferred adjudication.
Yes, sir. This was obviously years ago. I was not doing well. I was homeless. I had no vehicle. I was just not doing well. Um, it was a bad choice that I made. I have turned my life around since then, started school, work. Um, Honestly, it was just a very bad choice made. After my father died, I really had a difficult time. But since then, I have healed and I now study psychology. And I'm just trying to make a difference in my life and other people's lives and just do better. It was a mistake and I was a different person then. I can't say much more than that, and that I have changed and I'm trying to get my life on track.
Now, do you have other children besides your baby?
Yes, sir, I do.
How many do you have?
I have two with my first husband, and then I have twins, and they stay with their dad.
The baby that you reported as nursing, who does that baby live with?
With me.
All right.
I have a lot of close contact with my children. The two older ones are just old enough to choose where to live. So,
That means they're at least 12 years old.
yes, sir. One is 18 and one is 16. The twins are
Oh,
8 and they live
okay.
with their father.
The 18 is not under the courts anymore. That 18-year-old by law is considered an adult.
He's still my baby.
I understand. Now, if I order house arrest, which means you'll have to stay home except for necessities, um, you would be under a GPS, probably a global positioning device that would tell everybody where you're at. And if you leave your location where you're supposed to be, it'll tell us that too. Would that, uh, is that something you can live with for 30 to 45 days?
Yes, sir.
All right. All right. The court will recall the warrant, Patricia. I'm going to enter an adjudication of guilt. I find you guilty of the offense of uh, obstruction of a passageway, highway, or waterway. What are you earning right now on a monthly basis?
Between the both jobs, about $2,500.
Okay.
But right now my boyfriend is in school, so I'm pretty much the sole provider for the house. So I pay everything.
Okay. You're sentenced to excuse me, 40 days house arrest, full house arrest. Means you don't leave the house except for your immediate necessities for your family. That's groceries, and that's it. Otherwise, you stay home.
Yes, sir.
Your Honor,
Ma'am,
just to let you know, I sent you the judge's notes anyway, if you wanted to write on them.
that's a good idea. Let me open up the laptop of Rudy. When you has to quiet down your did you just send it, Patty?
Yes, sir, at 10:26.
There it is. Is that one F or two, Altersdorf? James?
One F, Judge, at the end.
Okay. Mr. Edelman, tell me specifically, number 5, what? On or about?
I'm sorry, Your Honor, I don't have the motion to revoke in front of me right this moment.
Okay, I'll just put on here, violated condition number 5.
I believe that the violation was that Ms. Fuentes failed to report to her supervision officer for the months of January through July of 2017.
Judge, that's absolutely correct. That's what we did on Friday.
Okay, court finds it is true that violated condition number 5 is alleged. Enter a finding of guilt.
Here's my Joe Biden book.
All right. I'll assess a $0 fine. I'll amend the matter and order a sentence of 40 days full house arrest. 0 fine, 0 cost. I have withdrawn or recalled the warrant. That'll take care of it.
Thank you very much, Your Honor. We probably need to give you a certification of notice of appeal signed and report and given to the clerk.
Yes,
So I'll
sir.
do that before we leave. Where should she report? Do you know, or should I just ask the clerk about that?
I'm sure the clerks will guide you on that.
Okay,
She'll
thank you,
probably have
Judge.
to She'll probably have, yes.
When did you want Ms. Fuentes to report to work release?
Work release?
Well, that's where she needs to go get the monitor for the GPS for house arrest.
Uh, Today is Monday by 5 o'clock today.
By 5 o'clock today. Okay.
Okay, sure. Thank you. We'll do it.
And
All
Your
right.
Honor, before
Thank
we're
you,
off the
Andrew.
record,
Thank you, Judge.
Hold on. Mr. Edelman,
we're off the record, would you please grant Ms. Fuentes any credit for time that she has already spent confined as a result of this case?
yes, sir.
For times.
Okay, thank you.
You're welcome.
Okay, hold on.
Your Honor, may I be excused for a few minutes?
Yes, you may.
Thank you. I'll return soon.
Your Honor,
Yes,
can Mr. Altersdorf
not yet.
be, okay.
Okay. All right, I've now completed the paperwork. That is the sentence. I have given her credit for time served. Okie dokie. All right, Mr. Altersdorf. Ms. Fuentes, I hope that in the future you stay out of trouble completely. I am not pleased that you absconded for all this time, 4 years. But you have apparently made efforts to prove yourself for the sake of your family. That's
Yes,
the
sir.
only reason. That's the only reason you're getting that kind of leniency. All right. You and Mr. Altersdorf are excused. You will need to present yourself while you're there at the court. Mr.
Yes, sir.
Altersdorf, sometime today, have her go in to the offices and back and place her thumbprint on the judgment and documents that will be required.
We're at the door right now, Judge. We were going in with the certification as well.
All right. You may not have the judgment yet because I have not completed sending it.
Oh,
It's on the way, but sometime today, have her do that.
okay. Yes, sir.
All right.
Thank
You're
you.
excused.
Yes, sir.
Thank you, sir.
You're welcome. Mr. Barrera.
Now I leave it,
Now
right?
it's-
Leave.
I'm present, Your Honor.
All right, you ready on Johnson Gilmore?
I'm ready, Judge. I unfortunately, I don't think she's on. I've called her numerous times. I feel like there's something significant or important that may have happened to her, Judge, because she was very eager about getting this plea done. But she is not present at this time.
I'll give you 1 week to present her. Otherwise, there'll be a warrant. Recall 1 week.
Will do, Judge. Thank you.
And are you, well, you've got 17 minutes to produce Jose Menchaca.
Judge, he's present, Judge. He's ready as well. We can proceed on that one.
All right. We'll wait for Mr. Edelman to return. Ms. Morgan, are you ready to go on the plea on this?
Yes, I can do it, Your Honor.
All right. Ms. Torres?
I'm ready,
Torres. All right. At this time, the court calls case number 626-509, State of Texas versus Jose Sabas Menchaca. Ivan Barrera is the attorney of record. He is present. Are you ready on this plea, Mr. Barrera and Mr. Menchaca? Are y'all ready?
We're ready, Judge.
All right. Patty, have you got the papers on this?
Yes, sir.
All right. Mr. Menchaca, are we on YouTube? Yeah, I see it. Mr. Menchaca, would you please raise your right hand? And by the way, you're muted right now. Mr. Menchaca, we cannot hear you because your system is muted. Where's the button for him to unmute?
Judge, he's in the same office as me. He not really good with Zoom. You give me 10 seconds, I'll walk over there and fix it for him.
There you go. It's high school time, all right.
Morning, Your Honor.
Good morning, Mr. Menchaca. We'll wait for Mr. Barrera to get back to his computer.
Yes, sir.
I'm back, Judge.
Very good. Mr. Menchaca, would you please raise your right hand? Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may put your hand down. Mr. Menchaca, you were originally charged with DWI with a blood alcohol content of 0.15 or higher. At this time we're proceeding, you have announced, your attorney on your behalf has said that you're going to enter a plea. Before we do anything further, there's several rights and constitutional protections that I want to make sure that you're aware of. These will be repeated several times during this proceeding. First of all, you always have the right to remain silent in any criminal proceeding. You have the right to remain silent means that you don't have to make any statement, you don't have to answer questions, you don't have to submit paperwork, especially papers that admit or confess to wrongdoing. Do you understand that right? That you
Yes,
have
sir.
that right?
Yes, sir.
And you're willing to give up that right freely and voluntarily?
Well, I guess just like you said, sir.
Well, it's not what I said. I'm reminding you, in order to enter a plea, you have to give up that right. Do you understand that you're giving up that right?
Okay, I understand. I'm giving up that right.
All right. You also have a right to a jury trial. That's 6 people from the community that are selected to decide whether you're guilty or not guilty. You also have the right to cross-examine or confront any witnesses who would testify if you went to trial. Those 2 rights you give up when you actually decide to enter a plea. You understand that? Pardon me?
I understand.
Okay. You also have, there's a right called the right to appeal. That right is a right that you and your attorney can exercise, you by yourself, him by himself, or the 2 of you together, asking a higher court to review the official proceedings in this matter, the record, and any evidence that was presented. You're giving up that right too in order to do this plea. Do you understand that?
Understand, sir.
All right. Now, there is also a right that you and the state both have. That's the right to have this proceeding in public. There's 2 ways that's done. One is in the public courtroom. That's the main way. But because of the COVID pandemic, we're not doing courtroom proceedings at this time. The other way is by internet, what's called a video conference. And this video conference is being placed on the what's called YouTube. That is a public broadcasting of this proceeding, shows you, myself, everyone concerned, and they see and hear us and what's going on. Do you understand you have the right to demand this be done in the courtroom?
Yes, I do.
And you're willing to proceed in this video conference on YouTube?
Yes, sir.
All right. Now, the first document, we're going to show you some documents, and all of them, with one exception, at the top, they're going to have information. It's going to have what you see right there at the top, above the title of the document, states consent to video conference, but above it, in almost all the documents, is going to have that information. It says cause number 626509, the state of Texas versus Jose Sabas Menchaca, in County Court at Law Number 5, Bexar County, Texas. Now, this particular document says states consent to video conference. That's, as I mentioned a while ago, you and the state have the right to demand this proceeding be done in the public courtroom. That document is signed by Mr. Andrew Harris Ailman, saying that he is in agreement to do this by video conference. Did you see and understand that document?
Yes, sir.
Now, all these documents, did you review them carefully with your attorney, Mr. Ivan Barrera?
Yes, sir.
All right. Now we're showing you a second document. At the top, it has the same information as before, but the title of this document is Discovery Acknowledgement. There's a law that requires that the state provide to you and your attorney information and evidence that is necessary by law and necessary so that you can make an informed decision. It's called Article 39.14 of the Code of Criminal Procedure. This is signed by the state's attorney and by your defense attorney. They're saying, yes, the state has complied with the law. Do you see that?
Yes.
All right. I will be signing that. The third document, this one again has the information at the top of it. Starts off with State of Texas versus Jose Savas Menchaca and so on. The title of this document is Defendant's Consent to Video Conference. This is the one where you agree to do this proceeding by video conference instead of live in the courtroom. This one's already been signed by your attorney. Did you sign this also yourself?
I believe so, sir. Yes.
Okay, proceed. The document you're being shown now, again, starts at the top with the information, the case number, your name, court number. Then the title is Defendant's Waiver of Constitutional Rights in Court's Admonitions. It starts off with 3 sentences, declarations by you. Did you read each one and understand it?
Yes, sir.
This one shows that you were originally charged with DWI with a blood alcohol content of 0.15 or higher. That means it's a DWI enhanced, meaning it's raised to a higher level. However, your attorney and the state have agreed that you're going to plead nolo contendere. That means you're not going to oppose it to DWI, and they're going to drop out the enhancement, the +1.5 or higher level of intoxication. That keeps it at DWI first. The rest of this document is divided into 15 separate numbered divisions or sections. Some of them is just one paragraph. The rest of them are multiple sentences in the numbers. The very first one there says the range of punishment that you can be punished is for DWI first is a fine from $0 all the way to $2,000 and jail from 72 hours to 180 days in jail. Did you understand that that's the punishment for this crime?
Yes, sir.
All right. Then you have numbers 2 to 15. Number 2 talks about, again, repeats the right to remain silent, that you freely, to cross-examine witnesses and the right to remain silent, and that you have a right to a jury trial, that you're giving those up freely and voluntarily. Did you understand all of that?
Yes, sir.
Have you ever received, have you ever had any kind of mental health troubles?
No, sir.
Have you ever been given any mental health medications?
No, sir.
All right. So you carefully read all these paragraphs 1 through 15. Is that correct?
Yes, sir.
I will point out particularly, where were you born, sir?
In Chicago, Illinois.
All right. That makes you a U.S. citizen.
Yes, sir.
That's important that we make the record of that. Now, all the way down to number 15. Number 15, you're giving that right up according to the papers and what's been said to me. You have a right to demand what's called a risk and needs assessment. That is a report that I could order. We'd have to postpone everything and have a study or report that will determine if you need help, either medically, physically, or mentally, whatever, emotionally. Do you want me to stop everything and get that report done, or do you want to proceed today?
I would like to proceed today, sir.
Okay, that's my understanding, and that's what we'll do. So you understood this whole document?
Yes, sir.
All right, and you will sign it or have signed it?
Yes, sir.
Now, the next document is titled Trial Court's Certification of Defendant's Right of Appeal. This is what I certify as a judge. There's a stack of little boxes. They're stacked vertically, and they each have, they each say something different about the right of appeal. The 5th box, I will check off. I am certifying that this is what's called a plea bargain case, and you have no right of appeal because this is a plea bargain. Did you understand that was going to happen?
I do understand, sir.
All right, then I'm signing that document. That'll be part of the record. Now, in this document that you're being shown now, again, the information at the top, this says application for deferred adjudication. Deferred adjudication is a very beneficial community supervision program. As a result of your attorney getting this done for you, or getting this deal, you will be entering a plea of no contest to the charge of obstruction of a passageway, highway, or waterway. I take it back, I'm sorry. You'll be entering a plea to DWI first, and I will be finding that there is sufficient evidence to find you guilty, but I'm going to defer that, meaning you will not be found guilty. It will be, in a sense, it'll be suspended. And if you live up to 100% of the conditions of supervision, and I mean that very literally, if you live up to 100%, then the case winds up being closed and the case gets dismissed, and you were never convicted of the charge, even of obstruction, pardon me, of DWI. I'm getting a little turned around on that. It is DWI that you're charged with at this point. Do you understand that that's what deferred means?
I understand.
All right. You need to particularly know and understand that if you violate the conditions, either you fail to live up to them or you refuse to live up to them, then the state can give me notice or send me a motion and ask me to give you official notice and bring you in for a hearing. And if the evidence supports it, I can enter an adjudication of guilt, and as a result, find you guilty, give you a conviction that will follow you the rest of your life. Do you understand?
I do understand, sir.
If you go through that, if you in fact screw up and we wind up entering a conviction, then you'll be looking at the full range of punishment, $0 to $2,000 fine and jail from a minimum of 72 hours to 180 days. Is that clear?
It's clear, sir.
All right. Now, the document now is personal data sheet. Did you fill one out?
Yes, sir.
All right. Who are you working for?
I'm working for myself, sir. Right now, I'm doing tree trimming and a little bit of yard work off my pickup truck.
And how much are you making per month?
Anywhere from $500 to maybe $1,000
Per month.
per month.
Do you file income tax, sir?
I have just recently filed my income tax. I will not be returned anything this time around.
All right. I want you to deliver a copy of your income tax that you filed. I want
Yes.
you to deliver that copy to the probation office. You understand?
Yes, sir.
All right. Will that show that you're making $500 a month?
I'm not certain, but I'm pretty sure it should show something like that. But I think it was because of the
COVID?
COVID, yes, that they sent me the check that everybody had got, and I think so that canceled out whatever I made in my earnings this year.
All right. Do you have any dependent children?
I have a 20-year-old son, and he's my partner. He works with me.
All right. He is by law not considered a dependent. He's an adult.
He is.
Have you served in the military?
No, sir.
Okay. You have a vehicle. What is it?
I have a Nissan Frontier, 2012.
Okay. All right. So, state, you have a motion regarding the original charge.
Yes, Your Honor. The state moves to waive and abandon the extreme intoxication enhancement and proceed as an unenhanced DWI.
Defense, any objection?
No objections, Your Honor.
Motion is granted. Now, to the charge of DWI first or DWI misdemeanor B, how do you plead, sir? Mr.
Guilty,
Menchaca?
sir.
You
Guilty,
pleading-
sir.
All right, your paperwork and your attorney have said that you're going to plead no contest.
No contest, sir. Okay, yes, sir.
All right. No contest plea is, as I told you earlier, that is sufficient for me to find you guilty. Do you understand that?
Yes, sir.
All right. Now, the court will be marking on the plea agreement that's being shown to you right now. This is a little bit different at the top. It just says State of Texas versus Jose Sabas Menchaca, and the case number doesn't have the court number.
Okay,
It'll mark, the first 2 boxes will be marked, and then you've marked the following 5 boxes where it says defendant's acknowledgements. Did you not understand what that said?
so yeah, I understand.
All right. Then you have, I accept your plea of no contest.
Correct, sir. No contest.
There will be a mark placed at the bottom of those, the last box, wherein the motion is granted to reduce it to DWI. Based on your plea of no contest, I find there's sufficient evidence to find you guilty, but I do not find you guilty because you have an agreement for deferred adjudication. I want you to appear within 7 days at the courthouse in the offices of County Court at Law Number 5. There's a hallway behind the court. You need to go there and put your thumbprint on the documents that they require you to do. Is that understood?
Yes, sir.
All right. I have found that there's sufficient evidence to find you guilty, but I am not. I'm granting you deferred adjudication for 12 months. You will pay a $500 fine. If you live up to all 100% of the conditions, then the $500 fine will be forgiven. You'll perform 48 hours of community service restitution. You can make a donation to San Antonio Food Bank at $10 an hour for each or every one of the hours of the 48 hours that you want to contribute instead of doing the actual work. That doesn't mean that I suggest that you not do the work. You're not making much, so do the community service hours. The probation office will guide you on when and where and how to do it.
Yes, sir.
According to this document, you're given credit for completion of the DWI education program, the victim impact panel, and $400 donation to San Antonio Food Bank. You already done that?
Yes, sir. Yeah.
All right. Well, you owe $80 more because I'm charging it at $10 an hour. Pay them another 80. Is that understood?
That's understood, sir.
All right. You will do you will enroll and complete the DWI education program and the DWI victim impact panel. You will submit to a TAP evaluation and follow the recommendations. You will have 6 months of ignition interlock monitor placed on your vehicle. During the entire 12 months of deferred adjudication, you shall not have any alcohol, not 1 drop. Is that understood?
Understood, Your Honor.
And the 6 months with the ignition interlock, it'll detect if you've been drinking, so you be real careful.
Yes, sir.
The supervisory fee I will set at the minimum, which is $25 a month. Questions, Mr. Edelman?
Nothing from the state, sir.
Questions, Mr. Barrera?
No questions, Your Honor, from the defense.
All right. Then that being the case, that concludes this proceeding. Mr. Barrera, see to it that Mr. Menchaca finishes the paperwork and the thumbprint issues. Don't forget he owes $80 to the food bank.
Understood, Judge.
All right. Then you all are
Thank you, Your Honor.
at this time. You're welcome.
Your
sir. Good
Your Honor,
luck
I
to
just
you.
need to speak to him.
All right. Mr. Menchaca.
Yes.
Ms. Maricela Luna is called a CLO, a court liaison officer with the probation office. She needs to meet with you briefly Patricia will place you on what's called breakout room. If you need a little help, Mr. Barrera's right there. Y'all will go over there and she will ask you questions, get some information, okay?
Judge, if everyone's excused, they can stay on. Miss Luna is now the host.
All right, then just stay where you're at. Ms. Luna will be asking you some information and stuff. All right, everybody else is accused. Ms. Torres, thank you for your help and your time. Mr. Edelman, Ms. Morgan, all of you, be blessed, be well, and be safe.
Marty,
Yes, I'm here.
can you go ahead and stop YouTube?
Okay. How do I
wasn't able
stop
to-
it?
Go to the YouTube where it says live. That button is stop.